So the first thing that I like to do is I like to get the students excited about the case itself. So we try to look through maybe the most exciting witnesses and their sworn statements to try and get some of the juicy information out and start to get students excited about what are the charges, what might be some of the salient facts, and we might just jot up on the board really quickly some of the most important facts in favor to help the Crown, as well as some of the most important facts to help the defense. But beyond that, the one thing I really try and get the students to understand initially is the standard of proof in criminal trials versus civil trials, because it can be hard for students initially to understand what beyond a reasonable doubt really means and the very high standard that they have to reach in order to achieve a conviction. And that's something that I also tell them, that in many of the mock trials, the facts favor the defense quite strongly, and in most of the mock trial tournaments, the Crown, or rather the defense, wins about 90% of the time. So it's actually quite hard for the Crown to get a conviction, and a bit easier for the defense to get an acquittal. But the teams really shouldn't understand, the defense shouldn't understand an acquittal to mean a win. The Crown shouldn't understand an acquittal to mean a loss, because in fact, an acquittal might happen even though the Crown was the superior team and gave the better performance. The second thing that I really would have wanted to know when I was first beginning teaching how to prepare for mock trials is that teamwork is a really essential component of the mock trial process, and that each team is really trying to present as clear and complete a picture of all the evidence as they can. So the Crown is really trying to present a complete picture of evidence that would prove beyond a reasonable doubt that the accused should be convicted, and obviously the defense trying to raise as much reasonable doubt as possible. But it's really important that the team members get together and try and establish the really salient pieces of evidence that they're going to need to prove in order to try and get the result that they want. And I think a lot of students get distracted with evidence that is not actually that important, because there are lots of things you can try to prove in an examination, for example, that the judge may actually not be that interested in. You have a limited amount of time for examinations and statements. You probably have 5 minutes for each. And so that really gives the teams and the students an opportunity to focus in on one or two really, really important facts in each examination that they're trying to bring into evidence. And the team should really get together and try and map out, a team, the Crown, for example, might only have 5 to 10 pieces of evidence that they're trying to bring out in the entire trial. And those 5 to 10 pieces of evidence should be interwoven through their opening statement, through their closing statement, and through all of their examinations, so that when the judge is listening to the trial, the judge feels that it all fits together, and that this is a team that's trying to show a portrait of a guilty person, and these are the, say, 7 pieces of evidence that they think prove beyond a reasonable doubt that this person should be convicted of the charge. And it's not 20 pieces of evidence. It's often a smaller number, but that the teams need to really zero in on. And one of the ways that over time I've learned to try and do that, and this is not necessarily easy for all students to do, but the ideal is, especially for student examinations, rather than writing a list of, say, 15 questions that they want to ask, writing instead a list of 2 or 3 pieces of evidence that they want to elicit during the examination. And the questions, if they practice them enough, kind of follow from the evidence that they want to elicit. They can write example questions, but one of the things students get tripped up in is following a script of 15 questions that they're going to ask no matter what the witness says. A great examination is one that responds and improvises and listens to the witness and improvises in response to unexpected answers that they get. Usually that's less in a direct examination when lawyer and witness can get together and practice ahead of time, and there are fewer surprises, though there can be surprises even in direct examinations when a witness forgets to say something or stumbles on an answer. But especially during cross-examinations, improvisation is the key, and if you're trying to bring out maybe one or two, or at most three damaging admissions to the witness you're cross-examining, you're going to have to improvise questions based on what answers you get, and that's what the judges are looking for. They're looking for how well you think on your feet, and that kind of brings us to one last point, which is speak slowly. Speak slowly, take your time, and if you focus in on one or two pieces of evidence that you're trying to bring out, then you don't have to speak in rapid fire to get all 20 or 25 questions out. Speak slowly. The judges want to make sure they hear your question. They want to make sure that the witness has understood your question, that the witness answer is to the clear and short and direct question that you've asked, and that you're thinking about what the answer is and improvising and responding accordingly. And if you slow down, you have an opportunity to think and calculate, okay, they've said this, and therefore I want to proceed in this direction. You don't want to immediately stare down at your paper and go to the next question. Look at your witness, listen to what they've said, and proceed slowly and carefully through whatever evidence you're trying to bring out. I definitely think that doing both sides gives them a sense of the weaknesses of each side as well as the strengths. It prevents them from ignoring weaknesses on one particular side. It increases the workload of the teams, and so that the students really need to be prepared to work really hard, because preparing a case for Crown and for defense takes a lot of work. And sometimes if you do a mock trial with an entire class, the team that you take to the tournament is going to have to do both sides. The teams that are in class might do one side, but they might do both. And I think it's definitely beneficial to the teams that do both in terms of how carefully they have to think through each side.